Hello everyone, my name is Muhammad Hanif bin Muhammad Izzuddin. So today I'll be talking about Seacera Group Berhad against Dato Lian and six others. So this is the case of company law that talks about notice for EGM. So let's get started. So let's talk about the background of the case of Seacera and Datuk Tan Wei Lian and six others. So the defendant, Datuk Tan Lian and six others, issued a notice of intention and notice of extraordinary general meeting (EGM) on April 30, 2019, as they requested a meeting on May 29, 2019. So the defendant requested the record of depository ROD as at April 30, 2019 from the secretary of the plaintiff, Seacera Group Berhad, on 8 May 2019. But the constitution of the plaintiff states that the notice is to be given at at least 14 days before the meeting, which means that the defendant have to serve the notice by the end of the business on May 14, 2019. So the posting of the notice only can be done by on the next day, 15 May 2019, which means that it is posted one day late than what they have to do. So the EGM was considered to be invalid due to the short notice, but the defendant requires to rely on the ROD of 15 April 2019. So to be post the notice to all their members and to avoid the short notice. So the issue of the case, wait, the issue of the case is whether or not the extraordinary general meeting be invalid by the defendant by posting the notice to the members of the company using the ROD of April 15, 2019 instead of April 30 that same year. So right here is the timeline of Seacera versus Datuk Tan Wei Lian and six others case. So April 15, they have the previous ROD. Then come to April 30, which the defendant gave the notice of EGM to the plaintiff. On May 8, the defendant requested the ROD for as of April 30. But in May 14, because they have to obligate with the 14 days notice, the defendant required to serve the notice, but the plaintiff handed over the ROD late, which causes them to post the notice the next day. And on May 29 is the scheduled EGM. So right here we have a video detailing about the case that we are talking about. So let us start the video. So the issue of this case is what happens if the given ROD of specified date are are given at the last minute and impossible to fulfill the requirement of the 14 days notice for 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 it to be sent out of notice. And can the date earlier and can the ROD dated earlier than the specified date of the required ROD be used? And should the court observe the conduct of the directors? So the fact in of the case is under section 147, subsection 4, of the Company Act 2016, any person name recorded in the depositor dated not less 3 days of the meeting is deserved to attend, speak, and vote in the meeting. But since the plaintiff omission the noti omission the ROD dated in 15 April 2019 that was not designed by the defendant, this causes an accidental omission means that to cover up the fact that consideration compared to this case. So the plaintiff has the obligation to ensure the facilities of the convening EGM instead of raising objections to the EGM based on the reason that they created. So the decision of this case, which the court has given to the plaintiff, is that the company can make requests to the central depository at the same day because the shareholders has deposited their money in the depository. So the notice that convening the general meeting to all members is an important matter because under section 321 subsection 1 of the Company Act 2016, a notice of the general meeting should be given to all members, directors, auditors of the company. Now, the reason of the judgment by the court is since the plaintiff delayed the ROD for April 30, 2019, the defendant were faced with a frustrated EGM since the ROD that they used were on April 15, 2019, which is a waste of time and cost since some of the shareholders are not in the listing. The EGM was considered to be invalid under the Company Act 2016, Section 582, Subsection 1, which stated that no proceeding under under this act shall be invalidated by the defect, irregularity, and deficiency of the notice or time unless the court is of the opinion that substantial injustice have been or maybe caused which cannot remedy by any order of the court. So that's all. Thank you for watching and see you all next time.